Mr. Willie Simmons versus Kansas Department of Public Health, Warden Sam Klein, Vincent Weary, Miss Johnson, Tamika Johnson, inmate Marvis Moya, and Ryan Stork. It's case number 21 CV 110. Plaintiff Willie Simmons appears in person pro se. Also present is Juliet Bennett, a sign language interpreter. And Miss Bennett, can you announce for the record what organization you're with?
Yes, Judge, I'm with Sign Language Interpreting Services.
All right. And as has been previous on this case, Mr. Simmons has requested a sign language interpreter so he can hear everything that's being discussed during the proceedings. We are set today on a couple of motions filed by Mr. Simmons. First one we'll take up is a motion to reconsider. It's titled Motion to Reconsideration of Unaddressed Issue Raised on the Default Judgment against Marvis Moya. If you want to go ahead and argue that motion at this time, Mr. Simmons.
How you doing, Your Honor? Your Honor, back then when you told me that I had to serve the health department, the general attorney's office, because they was an agency, but my argument is upon the KSA, the statute analysis 6304 and E, where it says allow service upon a corporation or other association, and stated that the service can be obtained by service of an office or a manager or a partner or a resident or a general agent. They stated that Kansas, of course, has not set forward a particular defining about a general agency. So my argument is that I did serve the general attorney, serve the health department properly.
Right, and just for purposes of the record, back on February 14th of this year, this court made a finding that the Kansas Department of Public Health had not been properly served, and that's what you're asking the court to reconsider, Mr. Simmons?
Yes, Your Honor.
All right, I did have an opportunity to read through your motion for reconsideration. However, KSA 60-304 subsection D has a specific provision for obtaining service on a governmental body. And D5 states that the state or any governmental agency of the state, when subject to suit by serving the Attorney General or an Assistant Attorney General. And that's the statute that I based that ruling on, Mr. Simmons. And the court finds that the Kansas Department of Public Health fits within the purview of 60-304 D5 as a governmental agency that must be served by serving the Attorney General.
But Your Honor, but up on the KSA, which you're saying is up on the KSA 6304 and E, you're saying that that's not proper served, because if a family member or somebody on the outside of the state file a lawsuit against the health department is not going to run to the general attorney's office to represent them if they being sued by, from their negligence. So what is the difference between, me properly serving them upon the 6304 E, serving them as a plaintiff, than someone on the outside that filed a lawsuit against them and the general attorney not representing them? Because the general attorney was in part, I'm not suing the general attorney, I'm suing the health department to the fact that, that even though that you saying that the general attorney represent them because they're agency, but from up under 6304, it's saying that, that I have to serve them at their office or a manager, or based in general of the resident. So if I was to serve them at their resident, you know, it would have been a proper serving. If I was serving them at their office manager, I'm serving the health department because of the fact that, well, that I'm suing them. I'm not suing the general attorney's office, you know, and you saying that they are part of an agency, you know, but up on the, but Kansas courts, they never set a presentation of anything about a general agency up under Kansas 60304, because it said it can be attained by service by office manager or partner or resident or a general agency.
Well, if your argument's under subsection E, that applies to corporations when the statute has a specific provision for governmental agencies, which the Kansas Department of Public Health is, and service on that agency has to be done by serving the Attorney General. The statute is very clear about that. I understand your argument, but I'm going to deny the motion for reconsideration on those grounds.
But, Your Honor, I don't think you're being fair, because I mean, the law in general, the case laws that I filed into my petition is in my favor, because I mean, when I filed the lawsuit against the general, against the state before, and Horizon at the time, you know, and the general attorney stated that they wasn't representing them, and there are an agency, and they had to get their own attorney. So the state health department have their own attorney and their own agency. So what is the difference between the attorney general not representing the Horizon at the time, and they had their own attorney, you know, and their own agency to represent them when I sued them several years ago? And then the general attorney state that they don't represent them. They only represent the Department of Correction, you know, as an agency, you know, because
the courts made no statements about the Attorney General's office representing the Department of Public Health. However, the statute is clear that government agencies in the state of Kansas have to be served through the Attorney General's office. And was, as I've stated several times, KSA 60-304 subsection D5. So if you want to join them to this lawsuit, you'll have to serve them by serving the Attorney General's office per the statute.
Okay, so what about the default on the inmate? I mean, he was properly served. He was here in the institution. I properly served him, you know, with the complaint.
Right. And the court already authorized default judgment against inmate Moya. Now, what we did, or what the court did at the time, was held off on awarding any award of damages to give you an opportunity to bring the Department of Public Health in. So the court's entered an order of default judgment. It's just an assessment of any sort of award of damages has not been decided yet.
So here's my issue. You enter a default judgment, which I haven't received a court order or anything in the mail on that.
You'll have to prepare that.
Excuse me?
You'll have to prepare the documents. The court doesn't prepare journal entries or orders of that nature.
So you said I have to prepare and send a document, a journal entry to the court? That's what you're saying?
Yes.
I don't understand.
You're representing yourself. You're responsible for preparing the documents that get filed with the court, including an order of default judgment based on a motion that you filed.
But I filed a default judgment, several motions on my default judgment on him and the health department into this motion.
The court entered an order of default judgment against inmate Moya already. It just needs to be journalized with the court.
So when you say journalized, I don't understand.
It means a journal entry memorializes an order of the court, an order that the court made on the record. It puts it in written form.
So you're saying that you're not going to do a single a default judgment? You're just going to wait until you're saying that I have to serve the health department, the general attorney office first? That's what you're saying?
No, that's regarding the Kansas Department of Public Health. Regarding inmate Moya, if you want to proceed to a hearing on damages without having brought in the Kansas Department of Public Health, we can do that as it relates only to inmate Moya, since the court's already entered an order of default judgment against him.
So can we do that now and explain to me what my damages are from what I filed?
Well, you'll need to lay out what you're seeking as far as damages go only against inmate Moya.
But Your Honor, the motion that I filed to the court was a separate motion on the damages with him and separate damages with the health department. You should have that motion. There's a separate damages for Morgan and separate damages for the health department.
All right, I do have the document. Is it titled Statement of Amount Due, filed with the court January 16th, 2025. Is that what you're referring to?
Yes, sir. All those documents was separate. His was in there, and then it was a separate from the health department.
All right, I see each of those, both of those documents. So the amount you're seeking, the total amount against inmate Moya is $20,000. Is that accurate?
Yes, Your Honor.
Do you wish to make a statement or argument regarding these requests, or do you want to stand on the statement that you filed?
I stand on the statement that I filed because all the facts and the issues and the evidence is there in the recording.
All right, give me a minute to go through this. What's the transcript fee? What kind of a transcript did you order?
Well, I had transcripts of my legal files, of all my recordings and my records that came up missing. All my property at the time, when the health department had us all transferred to Lansing Correctional Center, they took the responsibility. They joined responsibility at the time of the 72 hours. So they took joint responsibility when they sent me there, and then they told us that we had to leave our property in the cell for 3 days, 72 hours. So my property stayed in the cell with that inmate. So at that present time, all my property came up missing because of the fact that we couldn't pack up our property because the health department took responsibility and told KDOC to tell all of us that we had to leave our property in the cell, and they transferred us there. And when I come back to El Dorado, to the correctional center, and then I requested for my property, was looking for my property, all my property was missing. No one knew where my property was. All the evidence that I have sent to you is right there in the recording. And with their own admission, what they stated that, that my property, was missing. It told me file a property claim on everything.
So all of these items 1 through 10 were items of court documents you had in your cell?
Yes, Your Honor. Your Honor, the evidence would show that where their own admission from KDOC, where they have Mr. Morgan and several other inmates, where they was on videotape. The evidence is in recorded on the Form 9, stated that they was going in and out of my cell. They were stealing all my property. They took legal stuff. They took all my canteen. They took all my my appliance and all that stuff. Everything that I have listed on there, it was stolen. And the officers that's on my Form 9, you know, they did the investigation, and KODC did the investigation, and all that evidence in front of you and the recordings which show that, you know, that there was their negligence because they were responsible for my property, you know, when they sent me to Lansing at the time. And when it came up missing, they said file a property claim. And a property claim, they only give you only $500 for that. And at that present time, they told me that, you know, that they wasn't going to give me $500. So I filed this lawsuit in the process of the claim for damages for their negligence.
And you're seeking the exact same damages from the health department as well?
Yes, Your Honor, because of the fact that, well, that if when the health department took the responsibility of the 72 hours, then, you know, and they sent me to Lansing, then my property would never got stolen if they would have allowed me to pack up my property. So the same evidence applied to him applied to them. So my fact is, if you enter into a default judgment upon the upon Morgan with my property being missing, then the default judgment should be admitted upon them due to the fact that, well, that they held the responsibility at the time that my property got stolen due to their negligence, because they took joint responsibility of the 72 hours. If they didn't take joint responsibility of the 72 hours and telling KDOC, you know, because they threatened to lock us up if we try to pack up our property. So they transferred all of us to Lansing, you know, and that's how I lost all my property at that present time, because they took the responsibility of it. And this is why I'm suing them in the process of me catching the coronavirus, because one, they didn't follow protocols, and then they cross-contaminated us on the bus during the present time. And then I would never got sick and went into the hospital, you know, and this is why I filed my lawsuit for the $4 million on the coronavirus of the issue, due to the fact that, well, of me getting sick, you know, from all the evidence that I put into my documentations. You know, I sent all the evidence, you know, from what KDOC gave me, and I put forward for you to see, you know, all the negligence.
Right. Do you intend to try to serve the Kansas Department of Public Health still?
I mean, if you stated that up under KSA 60-304, and you sent an E that I cannot serve them properly up under that, I have no other choice but to go and reserve them, and then serve the General Attorney Agency, the General Attorney's Office. So if I have to, if Your Honor, where the confusion come in with me is this, Your Honor, if you said that you found a default on him, then by law, I read a case law. I wasn't prepared to come. I didn't know I was having a hearing. They just told me at the last minute. Because if you find a default on Morgan on damages, then the courts must find a default judgment upon them due to the fact of their negligence, because I'm suing them for the same, you know, the issue because of the damages.
I can't do that because they haven't been served. Now, I really think, since the line between who would be responsible for what, if anything, is if the Department of Public Health is going to be served, then there needs to be a full hearing if judgment's taken as to who's responsible for what. So I think it's premature to do an assessment of damages until you have all of the parties you wish to join in the lawsuit served.
I understand that. Okay, Your Honor, so why don't we just take care of Morgan, then I go and serve the health department, and then serve, the health department, we serve the health department and we serve the general attorney office as their agency, and we'll just take care of that issue, then we'll take care of the other issue behind that, if it's okay with the courts.
Okay, well, if you want to get the Department of Public Health served, the court will give you time to do that. What I was saying regarding assessing any sort of damages, I think you have to have all of the parties that you wish to join in this lawsuit served before the court can make a proper assessment as to who would be responsible for what in this itemized list of damages you submitted.
Okay, Your Honor.
As you're seeking that amount from both the Department of Public Health and from Inmate Moya.
I understand, Your Honor, but we still had 3 other defendants, Sam Climbs, and 3 other, Ms. Johnson and 2 other people that was in the lawsuits themselves. So the issue, the problem that became was, Your Honor, where you told me it was my responsibility to serve them, and which KDOC stated that it was a safety and security issue of a risk of them turning the addresses over to Mr. Simmons, because they didn't want me to have their home address. So I filed a motion to the courts and asked, out of respect, that the courts have the sheriff office to serve them. And up under Kansas law, when you file in the form of Parkinson or that the sheriff officers have a right to, when a summons is not being properly served, that, that they will look into and try to at least, find another proper way, if I don't know the address, and that they file a motion to the courts and ask the courts to have the KDOC to turn the address over to them, for them to be properly served, which that's another issue that we had, which you had denied me on that motion. So I cannot properly serve these defendants if the courts won't allow me to, have the sheriff office, or you give a court order for KDOC to turn over the addresses of the other defendants, for they can be served too, because those other 4 defendants in the case, along with the health department, or the defendants in the case itself.
All right, that's a motion that was taken up previously. There's no motion to reconsider that in front of the court at this time. So if you intend to serve the Kansas Department of Public Health, you certainly have time to do that. But any proper assessment of damages will need to be done at a later date.
So you said the damages with Mr. Morgan have to be done at a later date? That's what you stated?
Yes, if you still intend to bring another party into the lawsuit and you're seeking an assessment of damages for the same items against both parties, the court has to make an assessment as who is responsible for what, if anything. And that can't be done if there's still other parties that need to be joined into the lawsuit.
So basically you said I have to serve the health department and the general attorney's office.
If you're wanting to bring them in, yes. If you don't want to do that and you just want to proceed against Inmate Moya, then we can do that at some point. But if you're still wishing to bring other parties in, the court thinks it's premature to do an assessment of damages.
So let me ask you this, Your Honor, out of respect. So I go back and serve serve the health department, and you saying that I have to serve the general attorney's office because the general attorney's office is an agency that's going to represent the health department.
I didn't say that. The statute requires that any government, state of Kansas, governmental agency be served through the Attorney General's office. So that doesn't mean they're going to represent them. I don't know if they will or if they won't. But the statute requires that the Kansas Department of Public Health be served with a lawsuit through the Attorney General's office.
So property, I don't have to serve the health department, just serve the general attorney's office. That's what you're saying, Your Honor?
If you want to bring in the Kansas Department of Public Health, they have to be served through the Attorney General's office. So send the summons that you wish. Well, I can't really provide you with legal advice. I'm just reading you verbatim how the statute reads.
So I send my summons to the general attorney's office and not to the health department, based in general.
That's how the statute reads, yes.
Okay, I can do that. And you're going to hold off on the damages until further notice on Mr. Morgan.
Correct. If you're going to bring in another party into the lawsuit, you'll have that opportunity. And then at some point, we'll do an assessment of damages. But it's premature to do that right now if other parties are still going to come into the lawsuit.
I agree with that, Your Honor. Okay, Your Honor, could we just, today, we just dismiss Sam Climbs and we only keep the health department and then Mr. Morgan in the lawsuit, and I would just dismiss the other defendants in the case?
That's entirely up to you, Mr. Simmons.
Okay. I just file a motion to dismiss the other four and keep the health department and then keep Morgan in the lawsuit. So I only have two defendants in a lawsuit because this is basically where the damages come in at. So I just let the health department take the responsibility of the damages, what they did for the 72 hours.
So if you do get them served, they'll have an opportunity to have time to file an answer. And once all that happens, that will trigger a future court date. If you don't get them served or don't want to proceed against them, then we can get a hearing on the calendar to take up damages.
Well, I have my unit team to do that today. I'll fill out the thing for the sermons to the general attorney's office, and that'll be $15 as a service to the Senate, to the courts, right?
Yeah, I'm not sure what the fees are.
Yeah, because my unit team, they will not take anything off the books unless they have a court order saying that, that I owe the courts, or a record or something saying that I have to send something to the courts to the fact that, well, that as a summons or something to the courts.
Okay, well, I believe if you want to have them served, that will trigger something going through our clerk's office. But I'm not sure how logistically all of that works.
Well, I'll try to get something done this week and get them served, Your Honor.
Okay. All right. Anything else you feel needs to be addressed this morning, Mr. Simmons?
Yeah, Your Honor, I thought I was having this hearing about my $4 million. Well, but I see that, I thought she was going to grant my default judgment on them, but I see there's other circumstances now, so that I have to meet the requirements. So, but I'm going to go and check the law and see exactly what you're saying. So, and then I'll file my motion to the courts to you.
All right. All right. Well, if there's nothing further, then we'll be in recess. Have a good rest of your day, Mr. Simmons, and thank you, Ms. Bennett, for your services this morning.
And thank you, Your Honor, and thank you, ma'am. Appreciate your time.
All right. We'll be in recess. Have a good day.
Yeah.